All right, the court accepts as defendant's proffer pages 17 through 28 of the expert designation and opinions expected to testify to, with the line throughs being done by the defense. All right, Mr. Benioff. Be Court Exhibit F.
Right. Just so we're interpreting, my understanding is that they've struck through the things they're not providing.
That's my understanding.
Okay.
Yes.
So first,
Just one point of clarification, Your Honor. On the issue of gross negligence, there was an agreement with Dr. Shuffleberger not to use the word gross negligence, and in the email that I sent last night, it spoke about what Mr. Benioff refers to as the buzzwords, which are in the jury instructions that have been offered to the court, such as indifference, lack of any care, that sort of thing. So I just want to make sure that when the word gross negligence is written, that Your Honor understands that she would be speaking to that, but just in more phrases that are in the jury instructions and some of the case law.
all right, so if we can start on page 18, Judge, there's a line that suggests, and this is the second paragraph, it's the third or fourth sentence down, that says that Dr. Klinger is expected to testify that Dr. Parker did not show indifference to plaintiff as constitutes utter disregard, caution amounting to a complete neglect of safety of the plaintiff with respect to her involvement in the education of John Doe, including but not limited to January 6th. The issue there is that it seems to suggest that there's going to be testimony proffered that does not relate to January 6th, that actually is regarding to sort of educational duties generally before January 6th, which I think is impermissible and not an issue for the court, for the jury to decide in this case. And I figured I'd go one by one.
Right, so, I mean, I guess we need to clarify that then.
Your Honor, I think I can short-circuit this. She's not offering any opinions beyond January 6th. That was just an omission on my part when I was marking out.
Okay.
Yeah, I think I caught it in some places, but not every one.
All right, so if we limit that to on January the 6th, you no objection, correct?
Yes, no objection, with the exception that there seems to be later discussion of how she has educational duties, and whether she met those educational duties, I think, is an issue.
Okay. Well, we'll strike, just once again for the record purposes, I'm going to use X's since you lined things out. I'm going to use X's on this exhibit.
Thank you, Your Honor. That's a good
All right.
idea.
Okay, so that just is limited to on January the 6th. All right, next, Mr. Benioff.
All right, if we go to the bottom of page 20. Judge.
I'm also initialing those X's. All right,
Thank you, Your Honor.
for the record. All right, go ahead.
Bottom of page 20, there's a very last sentence says, Dr. Klinger is expected to explain to the jury that an assistant principal is not a law enforcement officer, does not receive law enforcement training, generally receives little education and training from a school board regarding how to respond to potential threats in the elementary school setting. There's a couple issues with this, Judge. First, I think it is well within the province of the jury that an assistant principal is not a law enforcement officer, and so in that context it's not helpful to any issue at fact. And then furthermore, this generalization as to what is trained or what information is provided to an assistant principal without being specifically focused to the case here, in other words, Newport News or even Dr. Parker, invites the jury to speculate as to whether that's true for Dr. Parker or whether Dr. Klinger is just saying this is generally true for everybody, but who knows how it applies in this circumstance.
Excuse me, counsel, can you identify which page you're referencing?
Sure, it's bottom of page 20, top of page 21.
Thank you.
All right. Any response to that?
Just a moment, Judge. Judge, I'd respond with respect to testimony that stating that Dr. Parker is not a law enforcement officer and receives limited training. I would agree that to the extent that she would testify that to the obvious that Dr. Parker is not a trained law enforcement officer, that is common knowledge. The jury can draw that inference from their own evidence and through their own independent assessment of what they hear. But I do think that it is the proper purview of Dr. Klinger to shed light on and explain to the jury that there is often an intersection between the roles that are typically thought of for law enforcement in terms of searching students for contraband, ensuring safety, that can overlap with the obligations of an administrator. And Dr. Klinger can explain to the jury that just because administrators and school teachers and staff often have to fulfill these roles and undertake certain responsibilities to conduct these types of searches, that does not mean that they are necessarily trained to the same degree that we would expect of law enforcement officers.
All right, I'm going to grant it as to is not a law enforcement officer. I'm going to deny it as to the rest with leave to cross-examine on those issues as it particularly applies to this case.
Yes, Your Honor. All right, ready for the next one?
Yes, sir.
Last paragraph, page 21, big paragraph. It's all about Dr. Klinger talking about mental health crises in children generally and attempting to, I think, equate that to circumstances here. I mean, we just heard from a forensic psychologist that says we can't offer opinions ethically as it relates to people we have not evaluated, and this seems to do it carte blanche, and she's not an expert in the field of psychology or psychiatry, nor is she an expert in the field of determining what is a pandemic in the context of mental health crises in America. And ultimately, it's not a helpful issue to the jury or the trier of fact in this circumstance.
All right.
Your Honor, we'll strike the whole paragraph. She's not going to be testifying as to that. It begins on page 21. Dr. Klinger is expected to explain and ends with overturning desks.
Court is in agreement. All right.
Next paragraph, page 22, we also object to, Your Honor. This is that Dr. Klinger is expected to testify or educate the jury upon weapon or gun talk or mimicking in an elementary school setting. Again, this is, essentially attempting to proffer inadmissible hearsay to say that to normalize this behavior, even though there's no basis for that opinion in the context of this case, or to be helpful in this circumstance. We don't know that any of the people here had any circumstance or observation of this gun talk or weapon talk or mimicking, and that this would sort of insert an issue in front of the jury about this generalization that is inapplicable.
Why would an expert be allowed to testify to this?
Judge, first, I think that she can testify based on her training and experience that these phenomena, including children who commonly mimic guns, commonly mimic weapons, is a frequent occurrence in schools. She can testify based on her training and experience in decades in serving as both a teacher, an administrator, an authority figure in these school settings, that this is something that is routine, and that is something that is not common knowledge to the jury, that would assist them in deciding material facts at issue in this case, including whether or not Dr. Parker's response to the reports she received were reasonable in light of the information that she received. We've heard evidence in this case that a number of the reporting parties who interacted with Dr. Parker subjectively believed that the object that JT might have possessed was, in fact, a fake or toy weapon. There's also been testimony from Alonzo Rawls that it's also very common for part of why he thought that there was not a credible threat or credible report at the time he spoke to Dr. Parker was that in his experience in dealing with children, they often confuse weapons with legitimate or innocuous innocent items, such as pencils, erasers, other objects. So this is something that Dr. Klinger can add her experience on. It would not be cumulative. It would be corroborative. In addition, it's something that will come from, will be necessary to provide context for the rest of her opinions. It dovetails nicely into the balance of her testimony, Judge. So for all those reasons, I ask that it not be excluded.
I'm going to sustain the objection. That is something that is can be commonly observed and taken as an experience. All right, objection noted. All right, next.
Your Honor, the next is the beginning part of the very next paragraph, where it starts with Dr. Klinger is expected to testify, And then it goes on to essentially state that Dr. Klinger is going to offer an opinion that what has been reported in the media or the press is inconsistent with her review or the factual circumstances of this case as she's found them totally impermissible. We've told the jury that they can't decide this case on what's out in the press, and to invite a witness to now talk about what they saw or heard in the media compared to what they've seen or heard in deposition transcripts, which, as Mr. Hogan's argument illustrates, what happens in depositions isn't always what happens in this courtroom, because Mr. Rawls never testified to those things, nor has Amy Kovac, despite their attempts to put in a video, testified to the thing that he said. And so for an expert witness to say, what I saw out there is not consistent with what I've seen in these papers, helps the jury nada.
You have a response?
Briefly, I would only say that to the extent that opposing counsel may open the door to the subject, it would be proper. But I would agree with counsel that this is something that should be elicited on direct, just injecting issues in the public domain into the court of law here. However, I ask that we have leave and reserve the right to explore those issues if they open the door to it.
All right, so you agree that Mr. Hogan, you agree that they have not opened the door at this point with Shufflebarger's testimony, but may on cross-examination with your witness. Is that correct?
That's correct, Judge.
All right, do you have any problem with that?
No, Judge.
Okay. All right, let me make a note on this. So the objection is granted to the extent that the door is not opened.
We don't think the entirety of page 23 ought to come in, Judge. We can take it one by one.
And so we're skipping the rest of that paragraph on 22. You're fine with we're now going to page 23?
Yes, Judge.
All right.
So page 23, when we look at the second paragraph, Dr. Klinger is expected to testify, and this is, again, involvement in education prior to January 6, 2023. As I articulated before, I think is irrelevant to the issues at bar. And then it talks about how public schools must follow federal and state laws which require that all children, even those with disabilities and those prone to disciplinary problems, including violence, receive a free, appropriate public education. Again, that's not an issue to be decided in this case, nor is it relevant or pertinent to an issue to be decided in this case.
Any response?
Your Honor, I think we can short-circuit this as well. Given the narrowing of the case by the plaintiff, we can omit probably all three of those paragraphs on 23.
Okay. Without objection, court agrees. All right.
That brings us to, at least in my view, the last paragraph on page 24, which is next. This is, and I understand from opposing counsel that there isn't going to be an attempt to parrot or to demonstrate any inadmissible hearsay or hearsay statements, but just to assert it for the record, essentially this paragraph attempts to do today, what they attempted to do yesterday, as it relates to video body camera footage.
All right, so it's all hearsay.
All hearsay.
From what I see. All right, any response?
Yes, Your Honor. I anticipate that we'll revisit these arguments later today, and so we can rule on them at the appropriate time. But I would just say that I would identify that none of these statements will be offered for the truth of the matter asserted. They are non-hearsay. They're also relevant and germane to this case, as will be established at this subsequent point in this hearing when we address those evidentiary issues.
All right, but not through this witness. You agree with that?
What I would say, Judge, on this point is that Dr. Parker, under Carter versus Commonwealth, as well as the Castillo case, a whole line of cases establishing that an expert may testify even on direct examination to an otherwise inadmissible hearsay testimony, provided it is offered for the limited purpose of explaining the basis of their opinion. That can be cured. Any risk of the jury not understanding that can be addressed with a proper limiting instruction.
All right, I'm going to sustain the objection. I'm also going to find that it's more prejudicial than probative. All right.
That gets us to page 25, the second to last paragraph. There's a sentence that begins with, rather, Mr. Rawls testified in his deposition And again, it's in the event that they ask her to parrot deposition testimony, it's impermissible. And I can further illustrate the argument, but it's 702, 703.
Okay, so that's that whole sentence.
Correct, all the way until the end of that
paragraph. Correct. All right, any response?
Judge, I stand on my prior arguments. This is the same issue. They can elicit this even on direct examination, otherwise inadmissible hearsay testimony, provided that it is offered for a limited purpose, namely to establish and explain the basis for the expert's opinion. I would note as well, Judge, with respect to the prior issue, some of this may be necessary or relevant to the subsequent evidentiary rulings as to the admissibility of video statements from Ms. Kovac that will be addressed later in these proceedings. I'd ask the court, to the extent the court sustains any objection at this stage, that we have leave to revisit these arguments at the appropriate time.
So I think they can have her testify to what she relied on, but I agree that he cannot parrot this is what Mr. Rawls said during the deposition. So I think it needs to be couched in the language by your expert that she relied on information provided in depositions, and from her understanding, the following things occurred. But is there an objection to that?
There is, Judge.
Okay.
And the reason is that while I agree the expert may draw conclusions upon otherwise inadmissible testimony, that's 703, the inquiry into those otherwise admissible testimony may only be done on cross-examination and cannot be proffered in direct. And so if I agree that they said, and in your review of these facts and information, did you review the deposition of Mr. Rawls? Yes. And did you rely upon the testimony of Mr. Rawls in forming your opinions? Yes. And what are those opinions? Here are my opinions. I agree that that's permissible. But the question of, and was there a determination that Mr. Rawls made that you found reliable that you then relied upon in your testimony? Yes, his belief was X. Is whether it parrots the statement or not, you're getting into facts and circumstances that are inadmissible through this medium. You know, Mr. Rawls testified to what he found and what he didn't find. And it may be an inquiry that's permissible in cross-examination, and that's addressed in 705, where it says in civil cases, an expert may testify in terms of opinion or inference and give reasons therefore without prior disclosure of the underlying facts unless the court requires otherwise. The expert may, in any event, be required to disclose the underlying facts or data on cross-examination. So that's what we're talking about here, that distinction between the two.
Judge, may I respond briefly?
Hold on, let me read the statements, then I will let you.
Thank you.
All right, so really there are two conclusions in this paragraph they're attempting to solicit.
I agree.
Okay. First one being, at the time of the shooting, it had not been determined that there was a credible threat. Right? That's the first.
Correct.
And then it says, and. Then the second conclusion, or facts, that until the shooting occurred and he went into Ms. Warner's room where he determined that John Doe was the shooter, he did not believe that anyone at the school was at risk of harm by John Doe that day. So basically, Mr. Hogan, you're asking her to testify to conclusions, or her drawing conclusions, that based on his statements. Is that correct?
No, what I would say, Judge, is she would be offering this testimony to explain the basis of her expert opinion. And part of that that's expressly contemplated under 8.01-401.1, which controls the admissibility of this type of evidence. That's been interpreted by the Court of Appeals in Castillo versus Loudoun County. That's 68 VA App 547. It's a 2018 case. Drawing on a huge line of authority, the court said unequivocally, it acknowledges there's a dichotomy between what's allowed on cross and on direct with experts in civil cases. Independent of that, regardless of that, additionally, quote, the otherwise inadmissible hearsay statements forming the basis of an expert opinion may be admissible for a purpose other than their truth, such as to demonstrate the basis of the expert's opinion. They cite Cartera versus Commonwealth, settled precedent that is 19 VA 516 from 1978, and that was a case where it wasn't just a vague description of hearsay statements made by third parties who were not present in the courtroom. There were explicit statements regarding the patient's symptoms and diagnoses that were admitted into evidence. And those were things that they were the statements themselves. The difference is that an expert can talk about those things provided that the jury is instructed this is to be considered solely to understand the basis of her opinion. So I would contend, Judge, regardless of whether we're referencing verbatim discrete statements or just characterizing them in a general form, this is admissible. It is contemplated under the law, provided that it is clear to the jury that this is not to be considered for its truth, which is not even offered for that purpose. Regardless, Judge, I would also say that looking at the statements themselves, I'm not asking Dr. Klinger to talk about or say that she made a determination based off of Mr. Rawls' conduct or his investigation. I just need her, the goal here is to have her testify that these were statements that she relied upon that will illustrate whether or not proper protocols by the administrator were followed in this case. Those are the material issues before the jury. And so all this can be cured with a limiting instruction. It is expressly contemplated under the law. If you look at Castillo, they cite at least 2 other cases supporting this well-established principle.
Any last word?
Yeah, Castillo's a criminal case, and 703, which is the same as 801-401.1, which Mr. Hogan cited to, explicitly differentiates civil cases from criminal cases. And what we're risking here is the precise thing that they're saying they don't want to that they're not going to do is exactly what they're offering it for. You can't in one sentence say, we're not offering it for the truth of the matter asserted, but then we want to show it to show the reliability or the basis for the opinion testimony of the expert. If it's not for the truth, then why did the expert rely upon it factually if it's not true? And so to say we're not offering it for the truth, but we're showing it to show what she based her opinions on is talking out of both sides of your mouth.
I find that that's more prejudicial than probative. It also calls for speculation. So you're allowed to ask her, did she review and read the deposition, and based on the statements by Mr. Rawls in that, did she come to conclusions? I'm not going to let her testify to what she believed Rawls' conclusions were. I think it's more prejudicial than probative and calls for speculation.
I understand, Judge. I respect the court's ruling. One thing to flag for the court, my understanding from the court's prior deferred ruling or ruling with respect to video evidence coming from Corporal Blythe, which contained Ms. Kovac's statements, I believe, and I took the court's comments for the bench to articulate that that evidence may be conditionally relevant. There's evidence that comes in our case in chief that establishes the requisite nexus to let this come in and make it relevant, then you would reconsider those issues. This may be the opportunity here. Dr. Klinger, if she's testifying as to how the reporting parties and intermediaries that interacted with Dr. Parker, what they subjectively believed and thought, if she's able to establish that as a factor for an assistant principal to consider, that is what this is oriented towards. It's not designed to elicit inadmissible hearsay or to prejudice their case. It is simply meant to explain, these are the documents that I relied on, this is what they said, here is why they are important. Dr. Klinger will testify that as an administrator in determining whether, when, and how to respond to information, they need to rely and depend on their subordinate staff, the first-line responders. And that includes their subjective assessment of the credibility or reliability of the reports they have first-hand knowledge of. This is all will come from Dr. Klinger, and that will establish the springboard for this additional evidence. So I ask the court to consider that, and to the extent that this court has ruled already on this objection, I ask the court to reconsider it and revisit it when I seek to introduce Ms. Kovac's statements through the video testimony?
Well, through this witness, it's going to be the same thing. I mean, she can testify what she looked at and what she considered and what conclusions Ms. Klinger, Dr. Klinger, can respond to, or relied on, and then formed her opinion based on, and what that opinion was, but not the exact statements. I'm not going to let that.
Understood.
They're more prejudicial than probative. So.
Understood.
Just
Okay.
for clarity, Your Honor, Dr. Klinger could testify that the material she reviewed, that it had been concluded that there wasn't a credible threat at that point,
I mean, that's her conclusion. If she's testifying that that's her conclusion, I'm allowing it.
without saying it came from Mr. Rawls,
Correct.
or that it was a toy gun, but not saying who said it.
Correct.
Okay.
Right. All right, next.
Page 26, Judge. Second paragraph. Sentence that begins with second sentence. Dr. Klinger is expected to explain to the jury that a student in Mrs. Warner's class was interviewed by law enforcement and said the following things. It's pretty much the same thing that we just addressed.
And I'd make the same rule. I understand you have the same arguments. I'd make the same ruling. She can testify to what she relied on, that there were statements, but not testify to those statements.
All right, next page, page 27.
And hold on, let me highlight specifically.
Yes, Judge.
And so really it's just that in that paragraph, first full paragraph, partial lines of that paragraph, if that paragraph has 1, 2, 3, 4, 5, 6 lines, it's the last two. So basically told interviewers that told Miss Warner that John Doe had a gun, and Miss Warner told him to sit down and save it for later. Those
Right.
are- okay.
That second paragraph,
Correct.
the first sentence is fine. The second
Okay.
part of it's out.
All right. Finally,
Last page, almost. Page 27. The paragraph that starts with additionally. And it says, Dr. Klinger is expected to explain to the jury the extremely rare nature of the incident at Rich Neck, and that John Doe is amongst the youngest school shooters in U.S. history, expected to discover the relative rarity of school shooters under the age of 10, inability to construct a predictive profile. Your Honor, I think all of this is immaterial and essentially asks her to assess the universe of information that's not even the universe of this case. It's saying, tell us how many other school shooters there are in this country, and that's not an issue to be decided by this jury.
all right. Defense response?
Yes, Judge, to respond. I would note that it is common practice. It's replete in the case law of examples of experts testifying based on their training and experience in their particular domain, that things are either uncommon, rare, occur often, or frequent. That does not run afoul of constituting irrelevant or speculative testimony regarding raw statistical data. It doesn't approach that in any respect. It also isn't something that's pure common knowledge. It is something that someone with the appropriate qualifications, training, and experience has unique knowledge about. They can testify to their experiences. Dr. Klinger is an experienced administrator, teacher. She's done this for decades. She can talk about whether or not this type of incident is rare. That happens in cases all the time. It happens in medical cases where doctors will come in and testify that these symptoms present. They typically manifest in this type of patient presenting with these types of symptoms. It is similar here as well. This isn't beyond the scope of her expertise or credentials either. This is something where she is a trained administrator. She's dealt with kids for decades and decades. She can talk about this and explain to the jury.
All right. I'm going to find that based on her training and experience, once again assuming that's established, that she can testify to the extremely rare nature of the incident, and that in her experience and knowledge that he's one of the youngest school shooters in U.S. history. However, I do have an issue with starting with the word inability. Actually, so let's just take that next sentence. In this regard, Dr. Klinger is expected to discuss the relative rarity of schoolships and therefore the inability to construct a predictive profile. I'm not going to allow any of that because there's no evidence that supports why that's relevant in this case. Assuming that's what you were saying, Mr. Beniozen.
Yes, sir.
All right. So I'm going to strike that sentence. And I think the next sentence is cumulative of the first two, unless you want to be heard on that. I mean, I think we're just using the same words over and over again. So I'd say that that language is met by your first sentence.
I think there's a difference between rare and unprecedented, and they're both here.
Well, she can only say it once. If she wants to say it's unprecedented and extremely rare, fine, but I'm not going to let her say it on two different occasions. That understood?
Understood.
Okay. All right, anything else, Mr. Beniozen?
Yes, sir. I apologize. But the next is an issue that was specifically part of the motions in limine, where it says finally, and effectively the witness is now venturing into things post January 6, 2023, and talks about how there is a difference in educational world within training of educators in the world at this stage as it relates to post 2023 incidents, and they can talk about post Rich Neck and these things of that nature. I think ultimately, Your Honor, there's a rule somewhat on point, which is 2407, which is the subsequent remedial measures. Obviously, this is a different situation because they're essentially proffering things that happened after the fact, but they're doing so in order to try and disprove negligence on the part of Dr. Parker by saying that since that time there are more safeguards that are put in place by school boards, there's more training about these things, and the issue there is we're going to be clouding the jury's understanding of, well, what did we know then? I mean, I thought I heard Mr. Hogan in opening statement say, you've got to ask yourself what happened then, not hindsight 2020. And now here we have this paragraph that says, let's talk about the world today.
So that's not specifically spelled out, so I'm assuming that's referenced in the deposition testimony of Robert M. Stewart. Is that where you're pulling that?
Correct. In other words, on the second page,
What page are we on?
we're at the bottom of page 27 going
Right.
on to page 28. So at the bottom of 27 it says, Dr. Stewart testified regarding post-Rich Neck changes in crisis management training, security in the schools, clear backpacks, weapon detection systems. In this regard, Dr. Klinger is expected to explain to the jury that in her work lecturing and consulting on school safety, after the Rich Neck case, there has been a dramatic increase in educators expressing concern regarding searching elementary school children. And so the question is, well, why are we going to tell the jury about things post January 6, 2023? I understand if you want to say this is the state of the world on January 6, 2023, and this is what the educational system was like and how training was on and up to January 6, 2023, but clouding the jury's assessment of what happened after the fact. Rule 407 is kind of a shortcut to these.
Which is remedial measures.
Correct.
Okay.
So all of the rules that come after 404 are essentially shortcuts to these determinations of what is unfair prejudice and what is confusing the jury. And by rule, the Supreme Court has said that when we're talking about things subsequent to an incident and it's being offered to demonstrate negligence at the time of the incident, it is inadmissible. It may be relevant to demonstrate other things, such as control, feasibility, things of that nature. And none of those exceptions are applicable here, because what they're offering this to show is not that Dr. Parker could have or did do something differently after January 6, 2023. We know Dr. Parker wasn't at Rich Neck Elementary School for much longer after January 6, 2023. So these are all circumstances and actions taken by people other than her in an effort, in my view, Judge, to argue to the jury, look, had the school system done these things for us.
Which is clearly impermissible under the rule.
Correct.
Right. All right, how is this, that testimony not violative of Rule 2:407?
Judge, simply put, 2407 as well as the statute, it incorporates 8.01-418.1, only prohibit the use of this type of evidence of subsequent remedial measures, to prove negligence. It is silent. It does not prohibit or prescribe using that evidence to negate it. Obviously, we're not trying to establish Dr. Parker's negligence. We are negating it. That is not prohibited under this rule. Counsel is correct that this is often shorthand to try to eliminate using evidence for improper purposes. There's public policy reasons behind this. The public policy reason behind the subsequent remedial measures statute is that you don't want to deter a defendant who, after an incident or crisis that endangered folks, from taking measures to improve that, to prevent that from happening in the future. That same policy rationale is not implicated. It is non-existent where the defendant is trying to introduce those measures to negate negligence. The rule is black letter. It is very clear. It only applies to proving negligence, not negating it. Why does that matter in this case? Because evidence of subsequent remedial measures, the fact that at Rich Neck Elementary School and other elementary schools throughout the country have implemented new safeguards in light of these types of shootings. There's a pre-Rich Neck and there's a post-Rich Neck. Pre-Rich Neck, these were the conditions that existed at the time. Post-Rich Neck, now we've got all these precautions, metal detectors, clear backpacks, all those things. That doesn't go to shifting blame to some other third party. It doesn't run afoul of the subsequent remedial measure statute, which only prohibits using this to prove negligence. Rather, it goes to the heart of foreseeability. A reasonable jury, viewing that evidence, can construe that had this truly been a foreseeable incident, had this been on anyone's radar, the staff, the teachers, the school district, that they would have had those precautions in place. That is legitimate evidence.
So what about his argument that it's going to negate negligence as well as basically for impeachment on the foreseeability issue, which is you did not do these things beforehand?
You did not do these things.
Yeah,
these
you
things
didn't have clear backpacks. You didn't have metal detectors, those sorts of things.
Right. And so in your question to me at this time is what about using those things in order to demonstrate foreseeability?
Correct.
The answer is we don't need to know that Rich Neck did those things after the fact. You can ask the question to the expert. On January 6, 2023, was there a policy at the school that required clear backpacks? No. On January 6, 2023, was there a metal detector at the school? No. You can ask the questions without the prejudicial nature of what somebody did after the fact, which is not a pertinent issue to this case.
Anything else you wanted to say?
No, Your Honor.
Either side have any case law to support their position on this one?
Not at hand, Judge.
No, Judge, I actually addressed this argument expressly in the defense motions in limine or the brief in response to the plaintiff's motion to exclude expert testimony. The authorities I relied on, I did cite some authority. It was largely treatises on this point, emphasizing that this is the purpose of the rule. I also did find one case, Judge, 2022 case. It's Davenport versus Utility Trader Manufacturing Company. That is 74 VA App 181, 2022 case. That is a published decision for the court, from the Court of Appeals of Virginia that is binding vertical precedent on this court. And it says that to assess whether Rule 247's general ban on subsequent remedial measures evidence applies, the court looks to two considerations. One, quote, is the evidence offered actually a remedial measure, i.e. a measure that, if taken prior to an event, would have made the event less likely to occur, end quote. And number two, quote, whether the evidence is offered to prove negligence or culpable conduct as a cause of the event, end quote. This is the plain language of the statute. The court applied that plain language. It doesn't prohibit negation.
I don't know if you're familiar with that case. You want an opportunity to respond?
I'm not, Judge. But I understand the plain language. I agree that that's the plain language of the rule. The issue here is what we're effectively asking the jury to consider is what did somebody do sometime later after the fact of January 26, 2023, and let's then use that evidence to decide an issue on January 6, 2023. And if the question is, were these things in play then? I agree. But you don't need you don't need the risk of prejudice that comes along with the question, this was implemented, or that became the educational standard, or this is how we train on things. That becomes unhelpful to the jury. If the question is only foreseeability, we don't care what's foreseeable now. We care what was foreseeable January 6, 2023, and the substantive issues of backpack this, training that. You can ask those questions without getting into what life is like post January 6, 2023.
My other concern, Mr. Hogan, is that regardless of whether or not that information comes in, you then go on to express in the disclosure that because of those factors that we've just talked about, there has been a dramatic increase in educators expressing concern regarding searching elementary school children. I mean, do you say that that's admissible as well, based on those conclusions?
Judge, I think it'd be appropriate to excise that from the opinion.
Okay. That I agree with. All right, so now we're really just down to whether or not she can testify that since the shooting, there have been changes to crisis management, training, and security in the schools, such as clear backpacks, weapons, detection systems, etc. Is that correct?
Yes, sir.
Yes, Judge.
All right.
And that's from Mr. Stewart, a school board employee's deposition, so she's read that deposition.
And that's the basis of it. We're getting back to the Mr. Rawls issue, which is if all she's doing is parroting somebody else's deposition testimony.
But can't she say that she, as part of her expertise, has reviewed that deposition and found that the school did these things? Ms. Benioff, any other response to that?
I'm reading the transcripts.
Sure.
If I can. I think that the second part of your sentence, that the school did these things, is the issue, because the school is not Dr. Parker necessarily, and so the implication and the purpose of the testimony is essentially to try and say, well, if only they had equipped her with clear backpacks, if only they had equipped her with metal detectors, if only they had done these things for Dr. Parker under that circumstance, then what we're doing in that instance is we're essentially pointing the finger at somebody, and we get into this empty chair issue. We're pointing the finger at somebody after the fact to try and make the job easier or different as it was on January 6th. Again, I go back to, we don't need to get into what anyone has done since January 6, 2023. You can get to the facts of those issues by just asking what was present on January 6, 2023. And if she knows that factually, she can testify to it. If she doesn't know it factually, which seems as though it's based within the record, she may not be able to testify to it factually if it's what Dr. Stewart testified to. She can just say, I reviewed the opinions and this is my conclusion.
Judge, have you heard? There was a new argument that was raised. I won't belabor the court with argument.
All right.
The new issue that was raised was a pivot by counsel emphasizing and relying on the empty chair doctrine. Let me just emphasize that that is a red herring in this case. We are not offering this evidence to point the finger at someone else for their own liability, that they were at fault, that they should have had these safety measures in place, and therefore, because someone else is at fault, we're off the hook. That's the heart of the empty chair doctrine. It is impermissible. That is not what is happening. It is well established. It is clearly settled in Virginia. There's a distinction between that, on the one hand, pointing the finger at someone saying, because they messed up, I'm off the hook, and pointing to overlapping evidence that is similar in nature to argue that this is unforeseeable as a matter of law.
I'm going to let her testify to those things exactly how we discussed it, but I'm also going to allow a limiting instruction that parrots that information, cannot be used to prove negligence, pursuant to Rule 2:407.
Or disprove negligence.
Yeah.
Just for clarity, Your Honor, in how Mr. Benihazen suggested the questions get asked, or can she say that she reviewed the deposition?
No, she reviewed the deposition, and those are the things that she found on her review of the evidence, and then we'll give a limiting instruction that that testimony cannot be used to prove or disprove negligence.
Your Honor, she's a national school safety expert. That happened all over the country. It's pre-Rich Neck and post-Rich Neck, just like pre-Virginia Tech and post-Virginia Tech. Standards changed.
Well, then you're just talking yourself out of that testimony, right?
I'm not talking myself out of the testimony. It's the same argument. It's the argument that's in here about the pre and post standards. We just spoke about that.
They just proffered to the court that it would only be offered for the issue of foreseeability of a weapon on campus. And then they've come up to say standards change on how we should judge their conduct. This demonstrates the exact issue when we have these sort of backdoor evidentiary issues, which is we're going to use it for this but not for that. And we start to get into this realm where you have an expert on the stand that says, well, the evaluator ought to do this. And he just doesn't say Dr. Watson. And so we're getting a backdoor attempt to try and address this issue as to the standard of care or negligence under the guise of a foreseeability analysis. And I'll point the court to this issue that there's foreseeability discussions throughout her designation that are not objected to. She talks about foreseeability, and we understand that she's going to talk about foreseeability. The question is whether she can say the world as it is today foresees the likelihood of a weapon on campus differently than the world saw it on January 5th, 2023, and that we don't think that that's permissible.
Judge, very briefly, the original argument was that Rule 2407 expressly prohibits this type of evidence. We just had a case, we discussed the case that says that it only operates to prohibit using that type of evidence to prove negligence. It has no operation or legal effect to prohibit using that same evidence to negate it. Us arguing that this is probative of foreseeability is no different. It's in line with what is contemplated by those rules. Foreseeability is the heart of negligence. It's embedded throughout it. That's why it appears in our briefs, it appears in our pleas, and that's why they don't object to it. This is a false distinction. This is a complete red herring, Judge. This rule doesn't operate to exclude anything. The better argument that they have is the one that they pivot to, which is that there's a Rule 2403 balancing issue here. And the case law is well established that any risk of improper bases or inferences being drawn from this type of evidence can be cured with a simple limiting instruction, which is what we'll be using throughout this case to address similar issues.
All right, I'm going to overrule the objection and allow limiting instruction.
Thank you.
All right, so what I'm going to do is I have made my notes and my marks on the original Court Exhibit F. I'm going to photocopy that for both sides so that that'll give you time to go back and talk to your witness.
And Your Honor, for planning purposes, obviously it takes a little bit of time to speak with our witness. When we shift gears like this, her testimony is probably going to take a fair amount of time. It might be a good idea to take lunch at this time, just because I don't want to get in here and then stop right away because of lunch.
All right, no, but you're not going to take, this can't be more than an hour, I would think.
We need a little bit of time to meet with her. It took a little bit of time with Dr. Hagan, as you know, just to go through the shift of gears, because these matters weren't determined at the motion and limine stage.
You have a position, plaintiff? Anyone?
I don't think we need an hour to tell a witness. You don't get to say these things.
Yeah, I'm going to photocopy it too for you. You can go and talk with her, and yeah, I want to get through her before we go to lunch.
Okay, Your Honor, that's fine, just as long as we can have a little bit of time to do that with her.
I'll give you 15 minutes. It shouldn't,
Yeah, that's fine, Your Honor.
Okay.
I just didn't know if you wanted to break for lunch at noon. That was my concern, or
Yeah.
12:30. I wasn't sure.
We got snacks for him.
Okay.
We, meaning the court. All right, we'll be in a 15-minute recess.
Please rise.